I'll call the first case on this morning's docket from Johnson County, case number 128145. Oh, I'm sorry. Case number from Sedgwick County, case number 129056, in the matter of the care and treatment of Martin E. Palmer. Would the parties please come forward? And would the parties state their appearances?
Jacob Ladani, counsel for the appellant Martin Palmer.
Thank you.
Please the court, Dwayne Carswell for the state of Kansas.
Thank you. And would the appellant like to reserve any time for rebuttal?
6 minutes, Your Honor.
6 minutes are granted. All right, with that, you may come forward and begin.
Madam Chairwoman, may it please the court. I'm Jacob Ladani, counsel for Martin Palmer. This appeal covers two sort of separate issues. There's an evidentiary issue and a issue of the legality of this commitment.
Counsel, I would like to start with the issue of preservation. The state raised some serious preservation issues in its brief. Did you file a reply brief?
I did not, Your Honor.
Okay. I have a lot of questions about whether any of your issues have been properly preserved.
Okay, well,
Let's start with the arguments about the admission of expert testimony. Tell me a little bit about how you think you preserve those arguments.
So first and foremost, trial counsel on this case, both through pretrial motions and through contemporaneous objections, objected vociferously and continuously to the expert testimony on both issues, both on embrasure of the ultimate issue and on the hearsay or conduit hearsay issue.
But did trial counsel ever raise these constitutional arguments that you've raised in the briefs?
I think trial counsel made the argument without saying the words. So the issues, both of which, so the conduit hearsay, the issue of experts just testifying through the elements, those are issues of fundamental fairness. Procedural due process is the amendment or is the clause that protects fundamental fairness. So Mr. Siebert, in pretrial motions, he said, and I'll do my best to get the quote right, he said, he asked for a Daubert hearing first and foremost. So that's asking for process right there. He was asking for a pretrial process. He then was saying his major concern was that the expert witnesses in these Kansas sexually violent predator cases, they get on the stand and based on the statutory allowance for experts to rely on evidence that would otherwise be inadmissible or otherwise be hearsay, they get on the stand and they say, in his words, you don't know what they're going to say. And so right there, there was a request for process in the beginning. There was a request for a hearing with an available relief, that being some sort of limitation on the Daubert factors. So I'd say right there, that's the beginning of preservation.
A request for a hearing is not the same thing as making an argument about procedural due process, is it? I mean, the whole notion of a constitutional violation there never came up in the trial court, did it?
It did not in the issue of the expert witness testimony. There was in the issue of whether the process, not prosecution, but this commitment is barred, it did under other terms.
Okay, well, we'll talk about that when we get to that issue, because I would be interested in hearing how you think that happened as well. But when we're talking about the experts, I mean, weren't the basic objections that counsel made in the district court simply hearsay and objecting to the legal conclusions?
Hearsay, objecting to the legal conclusions, they were phrased different ways. Mr. Siebert asked for a standing objection, but based on the current status of the law, the court there was some colloquy between him and the court that he couldn't actually have a standing objection. And so throughout the trial, he gave different labels to the same objection. So he'd get up over and over and say, foundation, same objection, objection, hearsay. And so he was actively renewing that same objection, which comes down to a whole line or body of objections around that specific topic.
But did any of these objections, were they ever made on the basis of a constitutional violation?
They were made on the basis of hearsay. And so as opposing counsel pointed out, there is no confrontation clause for civil cases. However, as I've argued, there are similar protections or analogous protections to the confrontation clause. So normally the hearsay objection is an objection under the confrontation clause. If it's in a criminal context, you jump up, you say hearsay, that is preserving a confrontation
Is it
issue.
though, counsel? It seems like we have case law that says that merely making a hearsay objection is not the same thing as making a confrontation clause objection, because there are different elements that have to be proved. Like, for example, if you make a hearsay objection, that's a question with regard to the admissibility of the evidence. The confrontation clause question, is that testimonial? That would never come up in just a basic hearsay objection.
I suppose, Your Honor, but we have the luxury of looking at this in hindsight and not being on the ground. I think that Mr. Sievert made every effort to preserve the issue in this as he was going, and that was in the context he was in. So he had made those arguments. I also think if he made the hearsay objection, there's a question if it's an issue of law and how that affects review, but I didn't brief that, so I'm not going to talk about that.
And I can appreciate you trying to do the best with the record that is available to you. But, part of what we are concerned about as well is the integrity of the process itself. And so if an issue was never presented to the district court, that means that that body never had the opportunity to contemplate that issue, to make findings or make a ruling on that issue that then allows us to review it in a meaningful manner, which is the crux of why 6404 is such a big deal.
I understand, Your Honor. And as you acknowledged yourself, I am working with the record I was given.
Yeah.
So looking through this case, all of this, I think it is an issue of fundamental fairness. That's what it comes down to. And if we really want to go into the factors where you can review something that hasn't been preserved, it goes again to injustice, fundamental fairness. And this is about fundamental fairness. And that's what I've tried to bring into this whole issue, is the way the KSVPA is structured. And some of these aren't the topic of appeal, so I'm not really going to talk about them, but there's a lot about the KSVPA that just is uncomfortable and weird and rests in these very strange areas of law and seems to draw weird loopholes. So on the one hand, it's beyond a reasonable doubt, and there's a right to a jury. But what good is that right to a jury if you can put an expert on there who's just going to read all sorts of stuff to the jury that they went through on their record? And I don't think, I've done a few of these. This one just stood out to me as particularly blatant. When you have experts, especially one who's a lawyer, who's just standing out there saying, well, he meets all the elements, he meets all the criteria. And I understand normally experts can embrace an ultimate issue, but this is so above and beyond embracing an ultimate issue. And that was something that Mr. Sievert also objected about, the embrasure of the ultimate issue, invading the province of the jury. And I mean, when you've got two people standing up there saying, yeah, the first element's met, the second element's met, the third element's met, the fourth element's met. And then you have, again, what is reasonably relied on and how does that make an exception for something? So you have an expert witness who starts going through prison files of other people to find statements about that person. At some point, where is there an end? There is a inherent conflict within the statute because it wants to veneer these constitutional protections onto something where it is trying to take a liberty interest away after a liberty interest has already been taken away. So
I'm curious, and I know you're running out of time on your opening, but I think that we have some other questions for you. But I'm curious, did you find any case law that draws the analogy that you are drawing that draws the connection between the confrontation clause and due process?
What I found was Galt, which basically it was words by another name. It was the same thing by another name. So they said there's confrontation and Galt. You have a civil commitment, you have a liberty interest, you have a hearsay issue. And so that was the connection I drew. I was trying to look for a standard where one court had applied the most analogous type of proceeding with the most analogous type of results to somebody and what the scrutiny for that type of proceeding was going to be.
Are there any other questions from the panel?
Well, we'll wait for his 6 minutes.
Okay, all right, all right. Thank you.
Thank you.
Thank you. Good morning.
Morning. May it please the court, Dwight Carswell for the state of Kansas. The issues Palmer raises on appeal were not properly before this court because they weren't raised before the district court. Although Palmer did challenge the expert testimony, he never framed that as a due process claim, which is the claim he raises on appeal. And he, in his brief, did not argue why he should be allowed to raise that for the first time on appeal, which the Kansas Supreme Court says you have to do if you're trying to raise something for the first time on appeal. So that completely forecloses his due process claim. As to collateral estoppel, similar issue there. He did not raise a collateral estoppel claim below.
He did raise res judicata.
That's a different issue. I mean, he's raising two different issues. And he is on that one, though, at least in his brief, trying to raise it for the first time on appeal. But that's still discretionary for this court, whether you want to address it or not. Because the district court.
Let's presume that we do.
Okay. So on the merits, all these claims also fail. On that collateral estoppel, it just doesn't apply here. There are two different arguments he makes. One is the Sporn-Sigler material change of circumstances issue. What happens there, that's actually res judicata, not collateral estoppel, which is what he's arguing now. But in that issue, that occurs when there's been a prior commitment and then that failed, and then there's a second attempt to commit someone. And the Kansas Supreme Court said, well, there has to be a material change in circumstances to make those two different cases. Here, there was never a prior commitment, so that's just not, those cases just aren't on point. Issue preclusion occurs or claim collateral estoppel when there's been a prior finding in a case, and then that same issue is being relitigated in a second proceeding involving the same parties. Here, there's no issue that's being determined. He's relying on the 2012 prosecution and claiming that it's the issue of whether that was sexually motivated or not. That was never determined there, as he said in his own brief. The judge never made that finding. And that's also not an issue in this case. The state's relying on the 1990 prosecution as the basis for the commitment, not the 2012 prosecution. So collateral estoppel just doesn't apply. Going back to the merits of the confrontation clause issue, as he admits, the confrontation clause does not apply in civil proceedings. So you have to frame it as a matter of due process, but due process is flexible. Depends on the circumstances. It's not, the confrontation clause principles just don't automatically apply in civil cases. You have to look at what's fair in the circumstances. When it comes to these particular circumstances, where experts are testifying about questions that are really within the scope of expert testimony. I mean, the questions about whether a person has a mental abnormality or personality disorder, whether they're likely to reoffend, whether they have substantial difficulty controlling their dangerous behavior. For an expert just to get up and testify, yes, I think the person does have a mental abnormality, but can't explain. They need to be able to explain the basis for that to the jury for their opinion to be reliable and for the jury to really assess whether they're a credible witness or not. So the experts do need to get into the facts and data that they relied on in order to really have a fair proceeding.
Counsel, it looked like in the In re Norris case, the court formed a requirement that for the underlying data to be admissible, the expert must testify that they relied on that data in forming their opinion. What happened in this case? Did that testimony occur?
I can't point you exactly to the record. I think the state does usually ask that question. I know there was no objection on that issue. I mean, that hasn't been challenged, so it's not been an argument on Palmer's point side.
Counsel, normally we don't let experts testify with regard to ultimate facts. So, for example, you can't have the expert testify as to the ultimate legal conclusion or the ultimate conclusion that the jury has to reach. Right? They can testify about their opinions to help the jury reach those findings or conclusions, but we don't let the expert kind of sit in the jury box and provide an opinion to the jurors. And so explain to me why that didn't happen here.
Well, first of all, KSA 60-456D does say testimony in the form of opinions or inferences. It's not objectionable because it embraces the ultimate issues. So it specifically
embraces, but not, yes, factor 4 is met, factor 3 is met, factor 2 is met.
I mean, the 10th Circuit case law that Palmer cites that interprets the corresponding federal case law says in these type of situations, experts can testify as long as they explain the criteria that are used and the reasons for reaching that conclusion, which definitely happened here. You know, both of the state's experts testified, I find he's a sexually violent predator because these are the 4 statutory criteria. And then with respect to each of those criteria, walk through why they believe each of those criteria was met.
And in fact, I think during some testimony of Dr. Crane, and perhaps it was after counsel objected, she even said, well, of course, the ultimate issue here is up to you, meaning the jury.
That's correct.
But here is my opinion. She noted that. Was there a jury instruction or something else to that effect?
I mean, the jury was definitely told that they need to find that all these elements are met, and it's up to them to determine whether the state proved those beyond a reasonable doubt. I would also point out within the Sexually Violent Predator Act itself, KSA 59-29A05D actually says that the expert should offer an opinion. I mean, after the probable cause finding, the person's transported for a forensic evaluation. It says as to whether the person is a sexually violent predator. So it specifically orders a mental health professional to issue an opinion on whether that person is or is not a sexually violent predator. So even beyond the general case law and statutory provisions within the SVPA itself, that's something that's committed to an expert opinion. So on the confrontation clause issue, I just also would point out that the limiting instruction that was given, it was to explain to the jury how they were to use this testimony, that they weren't to rely on what the expert said as evidence in its own right, just as an explanation for why the expert reached their opinion. So that further protected Palmer's due process rights to the extent he had them. I believe that covers all I want to address. If you have any further questions, I'd be happy to answer them.
Questions from the panel? No. All right.
Okay, thank you.
Counsel, you've reserved 6 minutes for rebuttal.
So I know you have questions. Before all of that, I kind of jotted down a few points. So first and foremost, if this is an absence of due process, it's denial of a fundamental right. I know that's not briefed, but that is an issue in all of this and how the court considers all of it. Secondly, the collateral estoppel res judicata was brought up, the difference, the proving some new form of dangerous, a change in mental state that is dangerous because, had Mr. Palmer, for example, not gone to prison or not been charged with anything, there wouldn't be a basis to start a type of civil commitment, which is what we see in Sporn and Spiegler, is that there can be a change where somebody who otherwise before shouldn't have been civil commitment is now or has developed into a state where they should be, and there is elevated dangerousness. But I think the big issue here is that when the state began this commitment, they cast a really wide net and they kind of tried to Frankenstein together 2 different crimes to get the things they needed. They needed the imprisonment, the term in the Kansas Department of Corrections for the commitment to begin, because statutorily commitment always begins from a point of incarceration. And then they needed the sexual offense. So on the one hand, in the original arguments and pretrial hearings over this, when there was an argument about res judicata, that was brought up that the state very much leaned into, well, the predicate offense is the 1989 conviction. However, you get into the testimony of the experts, and they are both testifying that, well, these things that happened in 2012, these things that happened in 2012, they add to the dangerousness. And
But aren't those two different questions? I mean, there's a predicate finding that must be met, that the defendant has committed a sexually motivated or a sexually violent offense. And then there is this person, or does this person continue to be a danger to the public? Those are two different findings, and that means they can involve different kinds of evidence.
they can involve different kinds of evidence, but that gets into the collateral estoppel issue right there. The state pointed out that the court didn't make a finding. Well, the court not making a finding doesn't mean that it's open. When the issue is resolved, when Mr. Palmer went to the Kansas Department of Corrections, the court had a choice to make a finding that it was a sexually motivated offense. That is something that would be moved for in the district court level at sentencing.
What was it necessary when there already wasn't a sexually violent offense on the books?
Well, I think so, because there'd have to be a change, and the state had to maintain that there was a change that would justify the civil commitment. And by accepting the plea or by presenting the plea offer, I think the state waived maintaining that there is a change. The state got a benefit out of it. They didn't have to go to trial. They got a guaranteed conviction.
Wait, doesn't the Easterberg case address this exact situation? So, the Easterberg court said it doesn't matter if the crime wasn't proven to be sexually violent in the underlying criminal case, you get a fresh crack at it in these commitment proceedings. So why wouldn't Easterberg resolve this situation?
And Your Honor, that's kind of blown out of my head in this moment. I'm happy to brief this afterwards if that's what the court needs, but I don't have a response to that right now. I'm sorry. So, but I do think, I mean, just going off of that with the idea that the state can get a plea agreement. And I mean, what Mr. Palmer was charged with, these were life sentence cases. And he had a prior conviction, so there were sentencing enhancements. If he had been convicted of aggravated indecent liberties, normally that's 25 to life. Off the top of my head, I think it bumps up to 40 to life. So the state waived a life sentence. If they could have taken this to trial and proven it, then the issue of civil commitment would have never come up in the first place unless Mr. Palmer were to be paroled, which would happen a long way down the line. So I think that comes into the context here too, that why didn't the state follow through on what it initially charged, asking for a life sentence, an off-grid felony, aggravated indecent liberties with a child under 14. It's a Jessica's Law case. And I know the Jessica's Law statutes have come since the Kansas Sexually Violent Predator Act was made law. And so to a certain extent, that has limited these civil commitments. But I think, again, there was something the state got and the state got a benefit, and they can't get that benefit and then get the benefit of coming back and saying, well, no, I think it's different now because we want this guy to be committed.
Other questions from the panel? All right.
Thank you very much.
Thank you very much. Thank you. We will take the matter under advisement. We appreciate counsel's argument, both in writing and today before the court. So we'll issue an opinion just as soon as we're able.